So I'm pleased to welcome to this panel two experts in this area. Left of me, Clinton Dew. He's a lawyer and partner of Barnes & Thornburg from Washington. Flight on Friday.
Yes. Directly
from the source. And Marian Niestedt. He's lawyer and partner of GVW Graf von Westphalen in Hamburg, and the readers of the Export Majors know him well for his articles in our newspaper about export control, like dual use themes that we discussed earlier this day. So, Clinton, first question to you. What is your definition of compliance in the context of transatlantic business? What is this difficult thing that we all have to think about?
Yeah, thank you, Gunter. And first of all, thank you for inviting me to come here, and also for allowing me to present in English. As I guess the only panel in English so far. That's a loaded question. It's a big question. What is compliance in terms of the transatlantic business? I think you have to break it up into bite-sized pieces. The sort of a hot topic that I deal with a lot over in the United States, and it started many years ago, decades ago, but was highlighted during the Obama administration, Trump, and now Biden, is investment screening. And I think that's something Marian's going to talk about as well. On the US side, investment screening is enforced, is administered by interagency committee. So 9 agencies, US government agencies, under the Committee on Foreign Investment in the US. So some of you may have heard about CFIUS. So I'm going to use the word CFIUS over and over again. This is this interagency body that reviews any foreign investment for national security purposes. And there has been a landmark change, a huge shift in investment screening in the US over the past 3 years. And it's because of a new statutory framework called FIRMA, the Foreign Investment Risk Review Modernization Act. And over the past 3 years with FIRMA, we have seen really 4 huge changes for investment screening in the US. We've seen the rise of mandatory filings. So in the past, it's been all voluntary filings in the US. After FIRMA, we have mandatory filings for foreign government type investments and critical technology investments. Number 2, we have an expanded jurisdiction. CFIUS has an expanded jurisdiction for minority investments. So minority investments in critical infrastructure, sensitive personal data, like if you have an acquisition in insurance companies or healthcare companies, iPhone apps, and critical technology again. Sort of the third thing is you have more CFIUS enforcement of non-notified transactions. So investors going into the US, and they choose not to tell CFIUS, they choose not to file. And so the US government has tripled the number of resources they have to find out about the transactions that were not notified. That's sort of the top 3 things. I could probably go on and on about various other changes, but I kind of want to focus on that. And then I'll talk a bit about German investment in particular and what we know so far in the past 3 years. And so based on recent data, and this came out about 2 months ago, the CFIUS annual 2020 report, we've seen some interesting numbers with regards to not only CFIUS as a whole, but German investment in the US as well. So let me start with the bigger picture. CFIUS as a whole has increased by about 60% the number of reviews after the statutory change. 60%, 60. That's a lot. They are much busier than they used to be. As it applies to German investments, we've seen in absolute numbers, triple the number of German investments in the US being reviewed. In terms of the ratio, meaning per country ratio, Germany used to be only about 2.5% of CFIUS reviews, pre-FIRMA, out of the various countries. Now they have more than doubled that. They are about 6% of what CFIUS now reviews on an annual basis, which isn't all too far off from China. China used to be reviewed, 3 years ago, they would be maybe 20 to 25% of the time were Chinese investments reviewed by CFIUS. Now they are slightly below 10%. Actually, this past year it was 7%. So now Germany and China being reviewed for national security purposes almost at the same rate, which is something I would not have believed would happen if you had asked me that a while back. So what do we look forward to in the future? It's a tough thing to say. It's hard to read the tea leaves for the Biden administration. And one thing that I'm going to point out and to tie into what Marion's going to talk about is the concept of accepted foreign state. So meaning in the US, for CFIUS, you have Canada, you have the United Kingdom, and you have Australia. Those three countries right now are accepted foreign states. What does that mean? They are exempt from mandatory filings. They are exempt from the expanded jurisdiction of CFIUS. And so is Germany going to end up on that list soon? German investors certainly hope so, but there needs to be sort of this robust investment screening platform, framework, before the US will put Germany on that accepted foreign state list. So that's what we're really looking forward to in the future.
Quite interesting. Yeah, because I mean, on the one hand, you say the system has to get more robust, the screening system in Germany. On the other hand, you want to attract investments from the US, who will then be reviewed by that standard first. So that's really an interesting approach. I mean, in Germany, the US investors are still, I think, the most important ones, at least by the top company. If you look at the direct investor, I think it's the Netherlands and Luxembourg, but if you look at the top companies, it's still the United States. And indeed, I mean, there are quite a lot of regulatory hurdles in Germany. If you look at investment screening, of course, you have in Germany the level of taxes, you have the lack of improvement in infrastructure, in particular in digital infrastructure, but also the investment screening is some kind of a hurdle for US investors, in particular as far as the transparency of the proceeding is concerned and the length of the procedure. In Germany, we have, it's called a sector-specific review regarding German companies being active in the defense sector, the IT security sector. You have other sectors where you need a mandatory filing in the critical infrastructure, and also regarding, of course, because of Corona and the pandemic, medical devices, in vitro diagnostica, etc. But also, and there the German law has been tightened last year, we have now a catalog of 27 scenarios, also covering artificial intelligence, 3D print, semiconductor industry, where you have a mandatory filing, and it doesn't matter whether the investor comes from China or from the US. And of course, what Germany is targeting at is China. No one would say that openly, I guess, but if you see the screening procedures in practice, the investments from China are reviewed in much more detail and much more thoroughly than US investments. However, at the start of the proceeding, you do not know how much time it will take. You have a 2 months initial review period for 2 months where Germany looks whether the essential security interests or the public order and security, depends on the cases, are impaired or are likely to be impaired. And then The other ministries are also involved, the Ministry of Defense, the Foreign Affairs Ministry, and if they say we want to look into it in more detail, you get into another step. It's a detailed review which takes 4 months, and it can even be extended by another 4 months, in particular if it's referring to defense industry. So it can take up to 10 months, and if you imagine a German startup company who needs investment at short time, and you tell them this procedure can take 10 months, they would say, thank you, goodbye. I go to another country, maybe, to invest. In practice, if you have a US investor, it doesn't take that long, but at least it's difficult to say if a client comes to me and says, how much time will this proceeding take? And it even gets worse if you think you have a coordination mechanism on the level of the European Union. Within the European Union, not every member state has to have implemented such a screening procedure. There are now 19 member states who have such a procedure, but irrespective of whether they have a procedure or not, Germany has to inform the European Commission and the other member states, and they can make comments. And this again takes, it's part of the proceeding, but it takes about 35 days, or can take up to 35 days. So it's really a question of duration of the procedure and of how much time it takes, and this also affects the US. And maybe one additional comment, I mean, this is some kind of the downstream. On the other hand, I think there's a close cooperation between the authorities in the US and in the European Union member states, and in particular in Germany. So if there's a Chinese investor, Germany will inform the US authorities if that's relevant in terms of national security. And I don't know, maybe we come to that, but that's also part of this new Trade and Technology Council, where they also want to foster the cooperation and the screening procedure.
Have there been results from the first round of discussions in this council?
I would say not really. I mean, this just happened. I think it was in June that this whole process of Trade and Technology Council, which is a kind of cooperation between the US on the one hand and the European Union on the other hand, that it has been launched. And now there was a first meeting in Pittsburgh, and they have a joint declaration, and they have founded 10 working groups. But it's more talk than action. However, I mean, it's important to start talking. I mean, that may have been a problem during the Trump era too, that they didn't, the US and the EU did not talk enough, and it really remains to be seen. I mean, the main, or it's also interesting to note what was not talked about. I mean, the steel tariffs, the tariffs on aluminium and steel imposed by the US, and the retaliatory measures imposed by the EU, the reform of the WTO. So I don't know how Clinton sees the results, but
I see the result very much the same way you stated it, which is that it happened. The fact that the event happened itself is significant. It was very much in doubt right after the recent deal with the U.S. and Australia for the nuclear pact. France was very upset. And actually, I think Secretary of State Blinken is in France this week to try to smooth over that relationship. So France was very much pushing for the delay of the TTC in Pittsburgh. So the fact that it happened is important, that it's a collective engagement, and that there is this, I wouldn't say common enemy, but a common challenge with China, right? Because they noted it that they are dealing with challenges with non-market economies. And when they say non-market economies, they are basically saying China. And so it'll be interesting to see what comes out of the TTC. There's going to be another meeting. We don't know when it's going to be next year, but it'll be here in Europe. And let's see how much progress the working groups make. The ones that, of course, that I think we are watching the most closely, export controls, there's a working group for that, and investment screening, a working group for that. And before I sort of move on from the investment screening piece, you mentioned timing, right? Because somebody may say, well, it's going to take me, I don't know, 4 to 8 months, and why should I invest here? In the US, there was that recognition, because for many years, CFIUS reviews took 4 to 6 months, or even longer, depending on if they were required to refile. And so one of the other major changes statutorily and in the regulations is that there's a fast track now, a shorter filing. They call it a declaration. And we've represented some clients recently. We've gotten acquisitions approved within 35 to 45 days. So it's significantly shorter. And I think that's one of the most impressive things about the investment screening changes, is that increase in resources, increase in clearances. So definitely the US wants more foreign investment. They have more tools in place to make that happen. So it's really interesting to see that happening right now.
I think a lot of companies have wished in Germany to also have such a kind of fast track procedure. At least we had one transaction recently where Germany were the fastest in Europe, was reviewed by the various jurisdictions in Europe, and I just received the information that another member state gave the clearance, but for once Germany were the fastest of the administrations to rule on that investment.
And German investors are the ones taking advantage of the fast track in the US. I mentioned that the tripling of the number of German investments being reviewed by CFIUS. A lot of that is because you have these investments in the past that they didn't really even want to touch the CFIUS process because it would take too long. And now that there's this fast track, there's been a significant number of that use in the United States of the declaration.
I understand that the way the US is dealing with investment screening is screen them fast and often, but let them invest. And in Europe, it's the way screen them very intensive, and after you gave the permission or didn't deny the investment, then you can do your investment and keep on. Is that the difference between the two types of investment administration?
I mean, I guess it might be a challenge to over-characterize that. I think there's still so much changing right now, but yeah, I see to a degree the US does want to present that, hey, our doors are open for investment. We can do it for you within the time frame needed at the speed of business, essentially is what they're saying. And that they say, not even Chinese investment in the US, they don't prohibit it, but I think, of course, Chinese investors are very reluctant right now to invest in the US. So I don't know on the German side if...
Actually, they are dumping all the Huawei equipment from the networks.
Oh, yeah, that's a touchy subject. I mean, Huawei is a big topic not only in the U.S. but in Germany as well. I mean, and it's part of the larger China strategy. You probably saw in the news the CFO of Huawei was released in the last couple of weeks. So a lot of interesting things that are happening. I don't know if you have any thoughts on that, Mari.
Yeah, I mean, in the area of foreign investment control, what the government would usually do is to conclude a contract with the investor and also the seller or the target company, even saying that you are prohibited from transferring technology to the acquirer. So leave all the know-how in Germany, and then, the question is whether that's still interesting enough for the investor. But at least I think there are statistics that we have Chinese investors, usually that is quite stable. I think there was even some kind of survey saying that if you have a US investor, they may skip out of it rather fast or faster than Chinese investors. Maybe that's because US investors may be more private equity firms or venture capital, etc. I think that's probably the reason for that, but I found that quite interesting.
So it's always a question, is it transfer for economic or business reasons, or is it to transfer technology for strategic reasons?
I mean, if you look at the official Chinese strategy, it's probably for strategic reasons, to get the know-how and also to be more autonomous as economy. I mean, what China does not have is, I mean, they are very good with certain technologies, but certain know-how they have no access to for the moment, and that was kind of China 2025, is it?
Mm-hmm.
Yeah.
Yeah.
So to get access to that technology, and I think that's, I mean, if you look at China, that's a state strategy, and everything I think which is of importance in China is somehow directed by be it the local or the central government. Probably. I mean, that's a bit oversimplified, but maybe in the end it's like that.
And what we see in China is that the government is increasing fastening the grip on the companies, the technology companies, and others like education or else. So will there be a division of the global market into the Chinese side, the US side, and we have to choose where we
That's probably a good question.
want to be
for
active?
Marian.
I think it's a good question
Difficult.
for everyone, but
I just don't want to answer that one yet.
no, I mean, it's difficult to say. I mean, I'm not the politician, but you can see it also from the Trade and Technology Council that there's a fine line, and that the European Union, in particular Germany, I would say, wants to have some kind of good relationship with China on the one hand, and of course, even more importantly, probably with the US. And the US, I think, is very much focused. That's my impression. That is something then Clinton can elaborate on. But my impression is that China is the topic in trade, with respect to trade issues in the US. And as German companies, you are really stuck in between. Also because now in China you have the new export control law having extraterritorial effect, at least arguably, if you re-export from a third country to another third country, Chinese origin items. But also you have the Chinese blocking regulation, which still needs to really be implemented, because it provides that, for example, Chinese companies may sue European companies for action, for civil damages. But first, that's my understanding, there has to be a prohibition order, really saying which laws or which US laws or third country laws are really targeted and which compliance with which laws is prohibited. So that's that is really the compliance nightmare.
Mm-hmm. Yeah, I mean, I agree. China, and I'm not a politician, fortunately, so I can speak a little bit more freely. Yeah, dealing with China in the U.S. can be a compliance nightmare. The majority of the work I do involves China to some degree. And in the last administration, the Trump administration, the attack and counterattacks of Chinese trade were done mostly unilaterally. And so I think we've definitely seen a shift in methodology and strategy by the Biden administration. They're really trying to come together with with their past allies where the relationship may have been strained, and take a more multilateral approach to dealing with China. And so we saw that as soon as Biden was sworn in earlier this year. Several months later, U.S. Trade Representative Tai, and various others in the U.S. government struck a deal on that, the large civil aircraft, the tariff, the dispute between Airbus and Boeing, which had been going on for almost 2 decades. 2 decades of this war, this dispute in the WTO, and tariffs on my personal favorites of wine and whiskey and cheese were subject to this tariff war between the US and the EU. And within months, there was a suspension, 5-year suspension of those tariffs. So that's a good step in the right direction. Obviously, there are conditions to that, right? So you can't have market distorting subsidization of either of the large civil aircraft producers. And then they have to work together towards non-market economy challenges, that is China. But there are still some hurdles remaining in this multilateral approach. I think you mentioned it, these steel and aluminum tariffs, that we call them the Section 232 national security tariffs. Those still remain in place. And there are some dumping and countervailing duties that apply to EU goods as well. So there's more work to be done, but I think what I see so far this year, it's heading in the right direction in terms of the US and EU trying to repair its relationship and looking forward to collaborating together on the Chinese challenges.
Another sign of that, I think, on the steel and aluminium tariffs, they are currently negotiating. It's not within the framework of the TCC, this Trade and Technology Council, but I think they try to reach an agreement until the 1st of December, because otherwise the EU counter tariffs will increase. So that's, and this is in line what you say, that we try to solve those problems to maybe concentrate on another.
I would like to shift to another location. Many German companies choose Mexico as a location for their production sites to deliver to the United States in the automotive industry and so on. What changed due to the USMCA agreement?
Yeah.
A is agreement, okay. US-Mexico-Canada agreement.
Yeah, well, okay. And for those of you that are familiar with NAFTA, it's basically NAFTA 2.0, right? But it's more difficult to say now, USMCA, US-Mexico-Canada Free Trade Agreement. And we've had a number of German clients come to us, the ones that import into the US or manufacture in the US or in Mexico, especially in the automotive sector, deal with the challenges. And the challenge really is in terms of 2 things. Content, so the percentage of US, Canadian, or Mexican content has gone up. That's required to qualify for duty-free treatment under USMCA. So this is called the Regional Value Content Requirement, RVC, especially in the automotive sector. It's sort of a phased-in approach, but you're looking usually anywhere from 65 to 75% of North American content has to be part of the good. So that posed a significant challenge to German companies looking to utilize, let's say, Mexican production. The other challenge is, and this is a new concept, it wasn't under NAFTA, is the labor value content requirement for the OEMs, automakers. And it has to be basically high value labor, and they have to have a certain percentage of high value labor. And so that's particularly difficult in Mexico, where you might have depressed lower wages. So we're constantly seeing not just German companies, but any other companies, US, Canadian, et cetera, Japanese investors as well, that try to shift production, now dealing with USMCA challenges that they thought were maybe similar to NAFTA, but not so much.
So there might be increasing investment by German companies from Mexico to USA, capacities from Mexico to USA.
Yeah, I think you will see a shift. I think you will see a shift in that. I think it's just so new right now. USMCA recently passed, and the amended regulations have only been around for about, maybe 1 year. So yeah, are we okay on time? I think we're probably running out a little bit.
We should take questions.
Oh yeah, definitely, sure.
Is there any question from the audience? Or from the live stream? Okay. Thomas Nürnberger mentioned this morning that his company follows a local for local strategy, mainly to be closer to the customer and overcome bottlenecks in the supply chain. But it would also shield from sanctions from other jurisdictions to some extent. Is localization a way to avoid US sanctions, Marian?
I would say, maybe you mentioned it to a certain extent. It depends a bit on which sanctions you are referring to. I mean, if the US sanctions are linked to the origin of goods, I mean, local sourcing can be a means to avoid sanctions. Let's take, for example, China. If you source everything in China and the key clients are also in China, that will of course help, I think. If, for example, you take, it's not a sanctions or partly sanctions issues, or to a certain extent also an export controls issue, but if you take Huawei and the question to what extent you have foreign direct products which are produced outside the EU but based on US technology or software. Clinton is the expert on that, but I mean, all these, if you just source locally, I think you can, I would not say circumvent, but make sure that, or mitigate the risk, let's say, to infringe US sanctions laws. So that can be a means, but for example, if those sanctions are linked to US persons and you still have a US person, I mean, that does not really help. So I would say yes, but only to a certain degree.
He mentioned computer chips for his Chinese production, but this is also a supply problem. To get enough chips for their production, even if it's low technology or lower technology, not the high-end chips. No.
I mean, it's also a question whether it's realistically at all. I mean, to supply everything from today to tomorrow locally, I think that only works for certain companies, and it's not a new concept. I mean, I think those coming from the industry here, they know the concept of pursuing localization, I think, for many, many years now. And still there are a lot of companies who think it doesn't help them out of their problems.
But coming back to the jurisdictions in China, USA, blocking each other, or the EU blocking, what should a German company with activities in or selling products, producing products in the USA, in China, in maybe in Russia, what should he do to avoid extraterritorial sanctions? How can they deal with the blocking? Because if you're applied to or complied to the U.S. sanctions, you will be blocked by the Chinese, and vice versa. So it's difficult. Back to the question: what will there be a division of global market? Only for a few products, maybe.
Yeah, I don't have the answer for how it's going to be divided. It's tough to predict that. I mean, secondary sanctions from the U.S. have been around for a long time, so that threat has always been there. And you sort of rely on traditional compliance mechanisms. You know, how good is your screening, right? Are you unintentionally doing business with certain parties that would, you could say, irritate the US government, and would that result in secondary sanctions? That's always been a threat, and it will continue to be. And I think the Chinese laws, they're brand new again. I don't know. I don't think they're going to pick the Chinese side just yet, because sort of this established framework with the U.S. and sort of this predictability, a little bit more predictability with U.S. sanctions, I think is good. Certainty is good for business. There's so much uncertainty right now with the new Chinese laws. So curious to hear what Marion has to think on that.
I would say that the Chinese laws, at least until now, they're some kind of a part of the toolbox. So there's a wide discretion for the authorities, and they could make use of it, but it's more than it's in place. And as soon as it really comes to a trade war, they may really implement it. I mean, as far as your question is concerned, with respect to the blocking regulations and if there's a way out of it, I mean, first, of course, we have to look at the concrete scenario. Russia, for example, wouldn't be an issue of the blocking regulation because it's not mentioned in the annex to the blocking regulation of the European Union. It's also not relevant under Section 7 of the German Foreign Trade and Payment Ordinance because the EU has also enacted sanctions against Russia. But the main problems are in particular Cuba, because the EU has no sanctions at all enacted against Cuba, and Iran. And then what you usually do, the typical scenario is you have to ask as a company to make a declaration that you do not re-export to Cuba, or that you do not make business with Cuba. And usually there's a carve-out provision that you can use in negotiations, saying to the extent that this is not in violation or does not contradict EU or German law. This is what you usually would use in such a scenario. Having said that, there's currently a process of improving the EU blocking regulation. There's a public consultation currently going on that started in September and it's going until the 4th of November. So everyone is invited to take part in that public consultation and to see if there are problems to solve that. And I don't know how much time we have, but to give an example, which is quite illustrative, is the Bank Melli case, which is currently decided by the European Court of Justice. So there was the opinion delivered by the Advocate General in May, and usually, or in most cases, let's say, the European Court of Justice follows that opinion. And the facts were that the Telecom terminated a contract with 10 companies having links with Iran, and one of them was Bank Melli, so they were interrupted from internet services and telephone. And Telecom said more than 50% of our general company's business and income is made in the US, so it's really important for us. However, the court in Hamburg asked questions to the European Court of Justice on the interpretation of the EU blocking regulation, and the main question, in my view, is who has the burden of proof, because under EU law, it's more the guidance. You are free to choose with whom you make business. But of course, if you do just interrupt your business relationship because of the US sanctions, that could be a contradiction of Article 5 of the EU blocking regulation, saying you may not comply with certain sanctions enacted by the US against Cuba and Iran. So that's the main question, on whom is the burden of proof. What was interesting was that the Advocate General said it's a blunt provision, so he was not really happy with it, and he also encouraged the legislator to improve the blocking legislation. But until that, we have to see what the European Court of Justice will finally say, probably even in October or November. But I don't know what the US companies say with respect to the Chinese blocking statutes, if they have issues on that.
It's certainly on their radar right now. I think just even understanding, it's hard for even Chinese lawyers that I've talked to fully articulate the ramifications of the Chinese blocking statutes. So to be determined, yeah.
You can read about in the Exportmanageronline.de on our website in German. Very much thanks to you for your advice and the discussion about transatlantic business. I think we have to take a close look to what comes, and you have to stay in close contact to your lawyer to be up to date to these issues. Thank you, Clinton. Thank you, Marian.
Thank you very much.
Thank you.
Been a pleasure.
And as Mr. Peach said, when I talked to him before, he said you can make an exclamation mark instead of a question mark after a compliance nightmare. So
Okay.
BAFA is also well aware of that.